Hello, everybody. I'll wait until everybody has joined into our meeting space before getting started. Good afternoon, and thank you for joining us for this Wednesday Wisdom webinar entitled Malpractice Avoidance Strategies, Tips and Resources to Protect You and Your Practice. I am Judge Jennifer Kuyrkendall Griffin. I am moderating this free CLE today for the Solo and Small Firm section, of which I serve on the Executive Council. We are an elite section of the Florida Bar that offers a number of great opportunities and resources, especially to those who are solo practitioners or in smaller firms. Today's presentation is actually open to all Florida Bar members. If you are interested in earning nearly all of your required CLE hours for free, check out the section and sign up. All of our Wednesday Wisdom CLEs are saved on the section's closed Facebook page to where section members can access these free CLEs at any time. Please check out our section and get more involved with the section. As to housekeeping matters, the audio feature is turned off for participants. So if you wish to ask questions of the speaker or need technical assistance, please utilize the question and answer feature. All questions will be addressed as they come up when there's a natural break as our speaker is speaking. I would like to recognize our sponsors, whose logos are included on the slide for their contributions to the section this year. Reef Point AI, Florida Lawyers Mutual Insurance Company, Clio, Alonzo Appeals, Gilbert Garcia Group, RT and AP Mediation and Law Group, and Sheila Ann Accounting. I encourage you all to explore the member benefits offered by the section's sponsors. Our speaker today is Peggy Hewitt. Before coming to Florida Lawyers Mutual Insurance Company, Ms. Hewitt was a 20-year partner of Jones, Hurley, and Hand, PA. Before joining a law firm, Ms. Hewitt was in-house counsel for the Walt Disney Company. Before Disney, she was counsel to the Orange County Sheriff's Office and an assistant state attorney. Her practice experience included over 120 jury trials and countless administrative hearings and appeals in the areas of insurance defense, employment and labor law, and workers' compensation. She has been designated an AV peer review rated lawyer by Martindale-Hubbell for more than 2 decades. Ms. Hewitt has an extensive library of articles and advisories for legal and risk management publications, including the National Retail and Restaurant Defense Association News and LinkedIn. Her Florida Bar CLE manuals and presentations include Trying a Difficult Liability Case in Florida. She has been an accredited CEU presenter for the Florida Department of Finance since 2002 and has created and presented dozens of PowerPoint-assisted seminars both for the CEU Institute and for her self-insured and self-administering clients, and has presented at the ABA Annual Conference and the NRRDA National Conference. Ms. Hewitt was raised in Florida. She received both her BA and Juris Doctorate from the University of Florida. She was recently nominated by the City of Winter Park Chamber of Commerce for Volunteer of the Year for her years on the Winter Park Autumn Art Festival Committee as their Director of Entertainment and Volunteer Coordinator. And a little bit of exciting news that I just learned yesterday, Peggy is retiring from Fleming as of the 31st. So please join me in welcoming her as our speaker and in wishing her a happy retirement.
Thank you so very much, Judge Kuyrkendall Griffin. I am Peggy Hewitt, and for the past 6 years, I have been the Resources and Services Manager for Florida Lawyers Mutual Insurance Company. We've been dedicated to risk management and risk reduction for our insured members, lawyers, and the Florida Bar at large. And I've worked really hard creating CLEs like the one we're doing today to help reduce the risk that lawyers face every day in our regular practices. As a member of the solo and small firm section of the Florida Bar, I'm grateful and excited to be your presenter today for malpractice avoidance strategies, tips, and resources to protect you and your practice. Our program today will be focusing on what we as Florida lawyers can do to practice safe practices and enjoy what in our vocation passes as peace of mind. We're going to be monitoring the chat during the presentation for your questions. And as Judge Kuyrkendall Griffin indicated, please use the question and answer feature. We hope to have time to answer your questions, if not during the program, at the end of the program. And I do want to answer the most asked question. If I didn't get my CLE credit number at the beginning of the program when the slide was up, I promise we will show it to the class again at the end. So you'll be able to access your CLE and file it in your Florida Bar profile. For those of you attending by telephone, we'll be reading it out a couple of times, so have a pen ready. Our program today is going to be talking about, obviously, risk and risk management. If the reality is this, if you practice law in the state of Florida or anywhere, you will receive it. The reality is that you very will likely receive at least one bar complaint in your career. Statistically, the average is 1 every 7 years per lawyer, whether it comes from your client, an adversary, a judge, or even a stranger. It costs nothing to file a complaint against a Florida bar member. And because the Florida bar, unfortunately, or fortunately for some, but unfortunately for some lawyers, makes it very, very easy. You can just click on the Florida Bar website, go to the Florida Bar for the public menu, drop down to lawyer complaints and discipline, and literally get a veritable menu on how to sue your lawyer. And when you have to understand that there's no fee to file a complaint against a lawyer, and there are no repercussions for a frivolous claim. And unless the person who's making a complaint against you actually commits actionable libel or slander, you have little recourse other than to just simply immediately face the claim or the complaint and defend. And we as lawyers swear to abide by the Florida rules regulating the Florida bar, all 824 pages of them. We're bound to slip up. We're lawyers. We tease each other that, we don't call it a practice for nothing. Well, what we're going to try and do today, as I've tried to do my career at Florida Lawyers Mutual, is see what we can do individually and collectively to avoid that. And I'm going to be using quotes in this: the inevitability of receiving a complaint to the bar or a suit for malpractice. I personally have had 2 complaints, one while I was in-house counsel at Disney, a disgruntled ex-employee of Disney with who sued us for wrongful termination, settled his claim, and 3 years later accused me of stealing his settlement check. That was a case that was easily resolved. Now for those of you who are much younger, I put the canceled check front and back into a fax machine and sent it to the investigator at the Florida bar, and that ended the complaint. The other one was an opposing party in a pro bono child custody matter. Opposing counsel apparently didn't do the job satisfactory to his client, but instead of complain against the other counsel, she made a complaint against me. That too was quickly resolved. But most claims and most complaints against attorneys can be much more serious, and you want to have a lot of resources available to you to help you should that occur. So let's do this. Let's see what we can do to maintain your risk. And I'm going to start with some pretty boring statistics. Malpractice claims by area of the law per the ABA survey, which is very close to information that we've also received from the Florida Bar through 2024. This is basically just a boring slide about statistics as to where the malpractice claims occur against lawyers practicing in any particular area of the law. And not surprisingly, it kind of tracks the same percentage of lawyers who practice in that particular area of the law. Nothing really stands out or jumps out. It seems to be that complaints pretty much blanket the entire practice of law. Let's talk about area practice trends in Florida from 2015 to 2023. I've talked about this before. Some of you may have actually attended one of my malpractice avoidance seminars in the past, and we do talk about this. And one of the trends that you see is it unfortunately tracks how the economy is doing and what disruptions there are in different areas of the economy. You can see from 21 to 2023, estates, trusts, and probate complaints were falling simply because of the fact that COVID was, a lot of the COVID related death litigation in probate, estates, and trust law was subsiding. So unfortunately, at the end of COVID, personal injury, slip and fall, and automobile injuries started climbing again because people were going out to places and driving there. So the economy and what's going on in our real world and our reality um, can kind of foreshadow what is going to happen, in the practice of law and where the claims are coming from and who they're against. More recently, from 2024 through the end of last year, personal injury remained the source of the greatest percentage of malpractice claims, followed by business transactions. Again, estates and trusts were easing. Real estate accounted for the most trust account violations. And of course, corporate and security claims, as the economy had its ups and downs, created the most, not only complaints against lawyers to the bar, but also lawsuits for malpractice. Again, go back to the ABA survey. Now, the ABA only does this survey every 4 years, and the last completed survey was in 2023. So we only have the statistics to that, but you can see the way the things trend, that the amount of claims kind of tracks the amount of work that is actually done. Claims tend to be higher for the beginning portion of a litigated claim and reduce dramatically after mediation, because as we all know, at least litigators know that 95% and lately even more than 95% of litigated claims are actually resolved before trial. So the statistics also reflect that. Malpractice claims by type of alleged error. Again, the ABA survey only goes up to 2023. And the great thing that we have seen is a fall in the number of lawsuits and malpractice claims against lawyers for intentional wrongs. So that has actually fallen. And administrative errors doubled. So filing issues doubled. A lot of people indicate that that is the result of the massive changes in the Florida rules of civil procedure. And some of those rules are still being litigated as well. Again, the reality, real life, what's going on in our vocational environment tracks very, very closely to what's going on in malpractice land. Let's look at claims by task and alleged error trends in the last 2 years. Interestingly enough, there was an article in the Florida Bar Journal very, very recently written by our president of the Florida Bar that indicated that trust accounting and inadequate communication is the most the most complained about issue with their lawyers. And as a result, there are a lot of the Florida Bar voluntary bar associations and Leadership Academy of the Florida Bar have made communication one of their focal points in continuing legal education in 2025. Misrepresentation and excessive fees, those are the ones that we don't really see a lot of that are reported to the Florida Bar and the Florida Bar disciplinary pages. Instead, we see the conflicts and personal behaviors in that page in the Florida Bar Journal that we all go to see if any of our friends or colleagues have been disciplined by the Florida Bar. Incompetence has grown, and the incompetence area of the increase in complaints and claims against lawyers have really started to focus on technology competence, cybersecurity competence. Those complaints are rising simply because of the fact that there is so much, there's the swift change and growing risk of cybersecurity issues really over the past 8 years have, terribly affected both solo and small firm attorneys as well as big law. The big law firms are the ones that get all the press, and we see that the ransomware issues and confidential communication breaches have made it into the news. Those are the ones that we hear about, and those are the ones that we're really lucky that they get the press that they do because of the fact that it has a tendency to send lawyers to resources for cybersecurity, training, education, and protection. And then, of course, the last one are criminal charges. There have been a lot of that in the Florida Bar Journal pages on disciplinary actions towards lawyers. It's kind of frightening how many of the cases of discipline against Florida lawyers are as a result of criminal charges. But we also have to remember that there are 120,000 members of the Florida Bar. There are over 90,000 members actively practicing in the state of Florida. I believe that there were under 3,000 actual complaints to the Florida Bar, and there were fewer than 300 cases of discipline in 2025. So we're looking at a tiny number of attorneys are actually suffer a complaint to the Florida Bar, and a much smaller percentage are actually disciplined, meaning there are a lot of frivolous complaints against attorneys out there. But again, we'd like to avoid those altogether. And that's just malpractice complaints by firm size. It basically directly correlates to the number of lawyers that practice in these particular areas. The majority of attorneys that practice in the state of Florida practice in solo and small firms under 30 members, and that is more than 50% of our active bar. Let's talk about the cost of a liability claim, both personally and for your firm. And again, and when I say personally, I'm talking about everything from loss of income, loss of time, loss of billable hours dedicated to client work, but also peace of mind. Malpractice claims. There's an enormous amount of psychological cost in this. The worst moment of my life was when I got that horrifying letter from the Florida Bar indicating that a complaint had been filed against me because somebody claimed that I'd stolen their minuscule settlement check. I think I threw up in my trash can. It was just horrifying to me. Nausea, just fear, striking into my heart because this meant there was a threat to my way of life. To most lawyers, I think your bar card is everything. That the stress that even though it only took me a moment to resolve it, it took one phone call and one fax to resolve that, but that's not the majority of the resolution of complaints against lawyers. Lawyers are required to hire an attorney in certain occasions. There's damage to your reputation. You have to, if you're in a law firm or a partner in a law firm, you've got to inform the partners, and you have to inform your partners that a complaint has been filed against you. And everybody's going to know it if you get served at your firm with a claim or for a suit for malpractice. What else does it cost you? Well, lost income. While you're defending yourself, when you're preparing your defense, participating in depositions, perhaps in discovery, preparing documentation. If you have to hire an attorney, the meetings with your attorneys, you're going to suffer from lost time and lost billable hours. I mean, there is actual lost income while you're spending time defending yourself rather than either prosecuting on behalf of your clients or defending on behalf of your clients. There's also a monetary cost. you have to pay that lawyer. Lawyers, so unsurprisingly, do not practice for free unless they're doing pro bono work. And there are very few of us who would qualify for pro bono assistance in a malpractice claim. There's lost time with clients, there's lost billing, and there's also lost opportunities. Um, I would think it would be very, very difficult for myself as an attorney to having to be in court defending myself in a malpractice claim and at the same time going out trying to be a rainmaker for myself or my firm and trying to encourage new clients to come and work with me. So opportunities can be lost during that time as well. And of course, there's always the home and family impact. There's nothing worse than the anxiety that's caused by a complaint to the bar against you as an attorney. So let's see what we can do again to avoid that. Let's do some risk management stuff. Avoiding legal malpractice claims altogether. And I'm going to start at the very beginning, and I do want to stress this: client selection and subject matter competency. This was a little bit more important, during COVID and after COVID, but we still do an enormous amount of work virtually as attorneys. I mean, we're lucky enough to have technology nowadays that it allows us to do an enormous amount of our work virtually, whether it be, hearings, depositions, meeting with clients, conferencing, mediation. Sometimes mediators allow us or some of our clients to appear in mediation. It's not optimal, and I don't recommend it because obviously you definitely want your client to absolutely be invested in their claim enough to be present at mediation or any hearing where there might be a disposition. So you want to meet with the potential client in person before accepting any type of engagement. And you want to talk, you want to know a little bit about the potential claim and is their claim supported by any evidence at that first meeting? Is the potential client prepared in advance of your meeting? If they are not, then they aren't taking this claim very seriously. They're not being supportive of their own claim. I'm not sure how they would expect an attorney to be supportive of a claim and be, anticipating a great outcome if the client themselves was not serious enough to be prepared to meet, very prepared to meet with their potential attorney. Your first impression of that client, is this potential client seemingly problematic? Or are they collaborative? Are they actively participating in the prosecution of the claim or the defense of that claim? And very importantly, what is your support staff's reaction to this client? You are not the first person in your firm to make contact with this unless it's in a face-to-face meeting perchance. This person has made at least an initial contact with your client, whether it be on your website chat or with a live person in your office, the receptionist, and then your assistant or paralegal, whoever is assisting you in your law practice. What is your support staff's reaction to this person? Were they problematic with your staff? Trust me on this. If your staff, if your paralegals, if your legal assistant is not happy with having to deal with this client, they are going to let you know it, and it's not going to make participation in the prosecution or defense of this particular potential client's claim if your staff cannot stand to have communications with this person, because they're going to have more direct and more often communication with this person than you, at least until the substantive parts of your representation when you're actually in court or mediation with them. And check your gut. Are you comfortable with the potential client? Are you personally comfortable with them? Are you personally comfortable with the matter that they have presented to you? If you're not, it's unlikely to get any better. And there's nothing worse than dreading having to see a client or dreading to have to work on a case, because that's when issues occur. You don't want to communicate with this client because they're problematic. They're going to turn around and file a complaint against you for failure to communicate. So you might want to think about avoiding that potential client altogether and make a determination that this representation is not for you. You should know something about the potential client before they actually walk through your doors, before they cross that threshold. There are a lot of things that you can do in order to find out whether or not this is going to be a good client or a bad client. There's procedures for conducting, first of all, conflicts. Is there going to be a conflict with this potential client? And in the age of law firm consolidation, when small firms with their clients merge with other small firms or merge into a larger firm, there there has been a serious uptick in conflicts of interest simply because of the fact that members of one firm may have represented another firm's client in the past or their adversaries in the past. And there are steps that you can take to remedy or get a waiver for that particular conflict, build a Chinese wall. But in certain circumstances, it might behoove you to make a determination that this is just simply not the case for you to take. Great tool and great resource for available to lawyers is the Florida Rules of Professional Conduct. We can go right to Rule 4-1.7 through .10 and see what the Florida Bar describes is a conflict of interest. And the greatest thing about the Florida Rules of Professional Conduct is they're almost like a primer on how not to get into trouble in any given case. I mean, it's a great guideline, it's a great outline, it's a great primer. It's a great educational tool. If you have a question about whether or not something feels good or looks good, there are a lot of occasions you can go right to the Florida Rules of Professional Conduct and just be handed the answer to your issue. Again, in the first meeting with a potential client, face to face, let's talk about communication with them. There are rules regarding communications with your client. Is a translator needed? There is nothing worse in the world than meeting with a client and getting just getting an incorrect impression of either them, the nature of their case, or what they want, simply because their first language is not your first language. So, team up with your firm team, the folks that support you, and make a determination as to whether or not you should invest in a translator if this is a client that you really wish to be retained by. Fully discuss the procedure of bringing or defending their case. Explain to them discovery and what their obligations in discovery are. Explain to them that they are as much a part of this process as you, the attorney, are. Explain to them that they are required to appear at certain events, that appearance is mandatory at mediation, that if there's going to be live discovery, depositions taken, they are required to not only participate, but actively participate. Always discuss the possible outcome of the case, but don't ever make a promise to them that, unfortunately, because of billboards and what we lovingly call the CSI effect, clients can come across your threshold and into your office with preconceived notions of what a lawsuit can do for them. This is not the lottery, despite what, some people unfortunately glean from driving down I-4 and seeing how many millions of dollars their attorney can secure for them. This is not a guarantee. Nothing in the practice of law is a guarantee, especially if you're dealing with the human element of a jury. Absolutely discuss your fees. Talk about your billing practices and procedures. And use your representation agreement as a template for this discussion. You can go through your representation agreement as the outline of your first discussion because it will cover fees. It will cover what you will be representing them in, what the representation will be comprised of, what you will and will not be doing for them during the course of your representation. Utilize that representation agreement as a template. Use it as the guide to your discussion with your client. And what do you do if you see some warning signs? What are some of the red flags that have come up, in actual cases against lawyers that they should have thought about and deeply considered when considering, taking on a new client, taking on a new case? Is the matter outside your area of expertise or comfort zone? During COVID, there were a lot of lawyers that were technically out of work. And I refer to workers' compensation, plaintiffs' attorneys. People weren't working, people weren't getting hurt at work. My practice when COVID set in and at the end of 2019 and the beginning of 2020 was I represented restaurants and airlines. No one was flying and no one was going out to dinner. Did I contemplate another area, branching into another area of law? Yeah, that might have crossed my mind. Fortunately, that's when I moved to Florida Lawyers Mutual and I took the job as resources and services manager. But then again, I wasn't changing my area of law. I was no longer practicing law. But for a lot of attorneys took on estates cases, trust cases, wrongful death cases, things that they may not have previously practiced. And the malpractice claims that were brought against lawyers in the state of Florida during COVID and after COVID reflected that. So stay in your wheelhouse. Do you know what you're doing? Then you have the clients who are seeking an unrealistic outcome. For example, the CSI effect or the billboard effect. Or they feel that the principle is more important to them than the recovery. If these are two neighbors fighting over somebody's tree limbs, extending into their property, this might not be something that you want to also participate in. Check to see whether or not the client has either been fired by other counsel, or have they brought this claim before? Are you not the first attorney on this case? If you look the case up, if it's already been filed and there has been a withdrawal by another counsel, you may want to investigate that. Has this client sued an attorney for malpractice in the past? Well, there is an insurance index for that. You can find out the answer. Are you at all concerned about the client's ability to pay? If they are unable to comport with the requirements of your representation agreement, such as paying a retainer, that might be a red flag that that there may be an argument down the road that they are unable to pay your fees, and then you've got to go into the brand new nightmare of trying to decide whether or not you're going to sue your client for unpaid fees or waive those fees to the detriment of your bottom line. And what is the sense overall? Will this claim create a risk to you or your firm? And this is basically just the basket that we throw all of these red flags into, things that we've talked about over the last couple of minutes. Basically, is this claim or this this client going to cause dissension in your firm between you and your team members, your support folks, your paralegal, even your receptionist? Is this going to cause problems between you and your partners? Is this going to make, any type of risk to your firm's bottom line? These are all things that you need to consider when considering a new client and or a new claim. All right, deciding yes or no. You've made a decision. Okay, the Florida Rules of Civil Procedure can help with that. There are a lot of resources out there to help you decide whether or not you're going to take a case and how to best do it. Let's talk about some of those best practices. If you've decided no, that you are not going to accept this client, you want to decline in writing, or if you are required to terminate representation later, you must do it in writing. Always advise in writing your decision to decline representation and make it final. We talk about what is the form, a formal letter of declination with explicit language that there is not an attorney-client privilege or attorney-client relationship, and that you are not embarking on their representation. Must be in clear and concise language. No legalese required here. So, make sure that's in writing. It's very clear that you are not undertaking their case. Always employ courtesy and professionalism. Never denigrate their case. Don't tell them you don't have a case. Explain to them in professional terms that this is simply not a case that you can undertake at this time or any other time in the future. Delivery methods. We are not texting this. Do it in hand or in person. The United States Postal Service provides this great certified return receipt requested product. It's only a couple of dollars, but it proves that you delivered your declination directly to that potential client, and you won't be sued later on when nothing happens. You won't be sued successfully if their claim doesn't move forward because they didn't hire counsel. No texting. Texting is not a formal or secure communication. Not all texting platforms are secure. The only time you should be texting your client is, are you in the mediator's parking lot? Do you need directions to this particular event? Anything else is not secure. You don't want to have to turn over your phone in the future because it's all of a sudden part of a complaint against you for malpractice or malfeasance. You just don't want it.
Peggy, a few moments ago, you mentioned the insurance index and that you would
Oh,
be able to access to see if a client had ever sued before. How do
yes.
you do that? Well, actually, the question was, what is the insurance index? And then if you could expand further, how do you actually do that?
Okay. There is actually, okay, this is terrible because it's been 6 years since I actually practiced as a litigator. This is something that is accessible by your insurer. Um, and I know it's accessible, and this is terrible. It's been a while. And I had somebody else do it for me. I can tell you what I will do if you will send me. I will add this to the resources for this and forward it to the solo and small firm, or you can reach out to me at Florida Lawyers Mutual at peggyh@flmic.com. I will get that procedure available. I hate to say this. I would hand it over to my investigator or my paralegal to just go index this. I know it's there because I learned about it first when I was doing Slip and Fall in the Magic Kingdom. I actually was able to find out that two couples who claimed that they were injured on Space Mountain were serial roller coaster ride complainants. And they basically just sued for their next year's worth of chiropractic treatment. But they had sued, I don't know, 6 or 7 different um, uh, uh, resorts what am I trying to say? Entertainment venues that had roller coasters in the past 4 years. So there is an index, and I don't have that information off the top of my head, but there is one, and your insurer can help you access that. Your investigator can help you access it.
Thank you for that, Peggy. I was
I
just going,
apologize.
I
I should have
that
this off the top of my head, and I don't.
no, that's okay. The mention of Space Mountain, it beats me up
Yes.
every time we go on it. So
Okay. If you're over 55, don't go on Space Mountain.
yeah. Oh, well, I'm not quite 55 yet, but anyway.
Actually, that was a lot of that was part of the best part of my job. I got to go see and play with the rides after hours. Written declination, do versus don't. Do not give specific advice about applicable statute of limitations or deadlines. Do not do this. If there is a typographical error in your letter to this potential client you are turning down, do not put in, you will be sued if that information is incorrect. If you tell them you need to hire other counsel because the statute of limitations on your claim runs on March 31st of 2025 or 2027. If there's a typographical error in your letter, it will be used as Exhibit 1 against you in the malpractice suit. Do not give specific advice about applicable statutes of limitations or deadlines. Mistakes are deadly. Do not indicate that their case is without merit. Do not criticize the client or subject matter. This is in writing. Your declination letter is a letter. It may be an email letter, but it is still a letter, and it will be preserved for posterity. And trust me, this will be exhibit number 1 in the claim against you. So let's decide to take the case. We are going to send an engagement letter, probably the one that we utilized during the course of our initial interview with this potential client. Always use a written engagement letter detailing the service to be performed and the services that will not be performed if that is applicable. For example, if you are a premises and product liability attorney and you've taken on the case of an injury that occurred on your client's property, but it also, or it, the person bringing the claim was at work at the time, but the accident occurred on your property. If you are not also a workers' compensation attorney, do not take on the obligation of also practicing in or representing them in the workers' compensation case. If they have workers' compensation insurance, they more than likely have dedicated counsel or counsel that certain counsel are going to be provided to them. So put in your representation agreement that I will be representing you in CR 26-000123, but you will not be representing them in any peripheral or related administrative case. If you're an employment attorney, you will not also be working on any other potential claim that you might have against your employer. What I'm saying is make sure that you put in the representation agreement what you will not be taking on if there are adjacent cases. Make sure that you refer to the rule forms, the rules of professional conduct. I mean, there's some great templates out there, and we're going to talk about that in just a second. But make sure that you customize the writing to this particular client. You can use a template, obviously. Do not cut and paste from a prior representation agreement. Use a specific template over and over again that has no prior client information on it. There have been successful claims against lawyers who made the mistake of literally bringing in a past client into litigation simply because of the fact that their name was not removed from a prior representation agreement. They were brought into the lawsuit frivolously and mistakenly, just simply because the attorney's office did not use a template, but used a cut and paste. A previously used um, representation agreement. There are great templates out there. Cut and paste, seek and destroy does not always work every time. Typographical errors, again, can be deadly and will be exhibit number 2 in the malpractice claim against you. Avoid forms, avoid the cut and paste past engagement letters. Again, there's some great templates out there, and we're going to talk about those resources. Utilize the language in the Florida Rules of Professional Conduct. And please, please, please include a description of your billing practices specifically. And go to the Florida Lawyers Mutual Insurance Company's website, free CLE for all page, where you can watch our representation agreements, how to write, present, and enforce them to your clients. We just filmed this. The solo and small firm section of the Florida Bar members put this on February the 11th. So it's very, very recent, very up to date. Go to floridalawyersmutual.com, currently available for free CLE courses. Check it out. John Rafferty, a member of the Solo and Small Firm Committee, did an incredible job putting this on. Go check it out. It's free. It's very, very good. John was just absolutely terrific. Kudos to you. The engagement contract checklist, have a checklist. Simple, plain, non-lawyer language. If they don't understand it, they can't competently sign it or agree to it. Define the client and the non-client. If you are representing the president of a company, but not the company, make sure that that's in there. Define the scope of services, what you will be doing and what you won't be doing. Define your client's role, what their responsibilities are. You have to answer interrogatories. You have to answer, you have to provide discovery. You have to participate in mediation. Make sure that your client's responsibilities are included in that letter. So there are no miscommunications or claims later. If they can claim they did not understand what they were agreeing to, if the language is so difficult or it's so convoluted that a jury of their peers can decide that this was incomprehensible, that also can, you're going to find yourself in a position where flowery legalese language did not do you any good at the end. Make sure your billing and fee arrangements are clear, that of the $10,000 retainer fee that you are accepting upon representation, 40% of that will be held back to pay future unpaid fees. And that you will be, once we get through the specific portion of that retainer fee, you will be receiving regular invoices every 30 days. And make sure you do that billing. And make sure that there is no limitation of liability or any disclaimer clauses in your representation agreement, because the Florida Bar has opined, not the Florida Bar, but Florida courts have opined that paragraph is void on its face. Billing and fee arrangements, collect the retainer when appropriate, determine the fees, make sure it's in writing. Frequent billing is key. Keep daily time records. It's going to save you a lot of time. If there is ever a claim for you for excessive fees, or you are being sued before your fees have been paid, or you make a determination that you need to recover those fees, and there's almost a knee-jerk reaction by clients and ex-clients who are sued for fees to sue you for malpractice. There's some great, again, I'm going to send you back to the Florida Rules of Professional Conduct, fees and costs for legal services. It is a template for what you should have in your fee agreement. And then, of course, you have to consider The wisdom of writing off or negotiating a bill, or, that's a whole webinar in and of itself. But keep it in mind and make sure you educate yourself on whether or not it is worth it to you to sue for unpaid fees. Again, there's an enormous amount of CLE out there on attorney's fees. Go check some of it out. There are great resources. There's some great opinions. There's some great stuff, put on by the Florida Bar on attorney's fees. And remember, if you do sue for fees, you can expect a counterclaim for legal malpractice. Client communication is key. There's no such thing as too much communication with your client, according to them. If you don't put reasonable guidelines on attorney communications at the beginning and put out your availability to them in your representation agreement, that can cause problems later. Mainly, you don't return their calls within a reasonable period of time. Communicate frequently and effectively, and document. Text messaging. Okay, this is something that Florida Lawyers Mutual actually puts on their cybersecurity and resources page. There are a lot of reasons not to text for anything other than, are you in the mediator's parking lot? A lot of us, if you go on the Florida Bar website to get communication information or contact information with lawyers, a lot of lawyers actually post their cell phones, because we don't have landlines anymore, but post their personal telephone numbers but make a statement, no text messages. Texting is a privilege, not a right. And you make it clear to your clients that they cannot text you constantly. It is, at some point in time, texting is no longer going to be a convenience. It's going to be an annoyance. And then when you put the kibosh to texting mid-representation, if somebody is committed to having you available or being able to communicate with you 24/7 on your phone through text, you are going to have a problem with that client. Always confirm in writing. I cannot stress this enough. Make sure that every client decision is confirmed in writing, even if you do it, it's best to do it live at that particular event, especially if it is dispositive of their claim. If you are going to mediation, take with you a pre-prepared mediation agreement that you have prepared, or if your mediator provides a mediation form, a mediation agreement form to use as a template, utilize that. Make sure that your client is familiar with it. And if you have authority limits, make sure that they are clear and your client initials by that authority limitation or that authority grant, because lots and lots of arguments and lawsuits occur as a result of mediation remorse. If your client walks out of the mediation somewhat happy or happy with the result, they've signed the mediation agreement, they go home and they are inundated by family members or friends or acquaintances who have also been affected by the Morgan & Morgan signs on I-4. They may file a complaint against you. I did not give you authority to resolve for this amount, or I did not give you authority to, give custody of the family dog to my ex, or whatever term that they are remorseful over after the mediation or settlement conference has concluded. And if they're not happy, it's unlikely they're going to try and make sure that you're not happy either. Make sure they see it, read it back to you, admit that they understand it, and initial that authority. Make sure that deadlines and client attendance requirements are in writing. Make sure you have return receipt. This is received. This is a great thing about utilizing emails, because you can actually put a requirement or a tag on all of your emails, especially when it has deadlines and client attendance requirements. You can receive, a receipt when your client receives it, when they open it, and when they read it. And if they claim later on that they did not receive it, you have actual proof that in fact they did. So you want, so email is great. Return, United States Postal, return receipt recorded, Federal Express letter, sign, make sure that they are signed for, spend the $2. Get that return receipt requested. It will save you an enormous amount of headache in the future. Advice and strategy regarding key issues. Make sure that they understand what it is that you are doing going forward and that they agree to that strategy. Make sure that they know the possible consequences of choosing not to follow advice. I actually have a t-shirt that says, do it right the first time. Do what your lawyer tells you to do. Let them know what the consequences of not following your advice might be. Talk to them about the possible consequences of foregoing certain claims or remedies, or dismissing or dropping claims. Things happen that make, neighbors might decide that I'm not going to sue over the limbs overhanging the fence, but I am pursuing the fence that is on my property line. They drop that portion of the claim, or you drop that portion of the claim in a formal motion to the court, and then they say later on, after the argument with the neighbor gets heated, I never gave you permission to drop that portion of the claim. And whatever you do, if there's any post-engagement enlargement or limitation on the scope of your representation or work to be performed, that is memorialized in writing. Make that an addendum to your representation agreement, and make sure it is signed by your client. Get it in writing. Other malpractice pitfalls. We're going to talk a little bit about cybersecurity real quick at the end. There's a lot of cybersecurity, CLE and education out there, a lot of warnings, but attorneys unfortunately continue to make mistake after mistake after mistake, and the penalties are getting higher as judges get angrier. Deadlines and calendar errors. Use all that software that you've got. Make sure it's in, and I don't know if this is terrible. Are we still using the Red Book? Make sure it's in writing, not just on your computer. Computers go down. Ransomware occurs. Cybersecurity could shut down your access to your computer. You can lose your phone while traveling. Make sure it is in writing. Make sure it is pen on paper. Back your stuff up. Follow the Florida rules of professional conduct again. 4-1.3 outlines what, diligent representation really is. And you live in Florida. Prepare for disasters. Avoid electronic shutdowns due to power outages, hurricanes, floods, quarantines. Southwest Florida lawyers were down for months after the hurricane a couple of years ago. I did a webinar on it. For the love of Pete, make sure that you are prepared. Back up your computers and your servers. Make sure it's backed up in the cloud 6 ways to Sunday. You don't want to get sued because you don't have your stuff. Again, other malpractice pitfalls, cybercrime, loss of confidentiality in your client communications. Do not use AI. Don't use ChatGPT, the free ChatGPT, and put any client information in it. You just waived confidentiality, and you have just committed malpractice. Use of electronic devices. Hang on to them. If you've got a thumb drive and it falls out, you just lost confidential communications, and somebody can just pick it up and you are about to be sued for malpractice. Stay up to date, computer software updates, professional audits and pen testing, cybersecurity programming through the Florida Bar, the Florida Lawyers Mutual, free for all cybersecurity resource center, the cybersecurity and technology committees, their publications, there's education, the Florida Bar Tech Helpline. Thank you, Liz, for telling me that the tech line is no more, but we still have legal fuel, which is part of the Florida Bar benefits package. Guidelines offer the framework for law firm cyber resilience. There's a lot of stuff out there. There's relevant resources everywhere. If anybody wants a copy of the slides to this, they can contact the Solo and Small Firm Committee. They have a copy of the slideshow. I have the slideshow. Obviously, if you would like a copy of these resources, just reach out. We will give them to you. We want to keep you safe. Give us a call. Go on our website. We've got a ton of resources. The Florida Bar, Legal Fuel, it's out there. Go take it. And that's the end. And here's your CLE slide
Thank
again.
you, Peggy. We do have one open question. The
Yes.
question is, if I get a notice that someone filed a bar complaint against me, what should my immediate next steps be? Should I contact the bar? Should I contact an attorney? I tell my criminal clients not to talk to cops. Talking to the bar after getting a complaint feels like talking to the cops.
Okay. First of all, everything that people are afraid to call the bar. People are afraid that they're just trying to get you. That is the farthest from the truth. The Florida Bar loves their lawyers. When you contact the bar, when you get the letter, it comes from an investigator who is hired and is an employee of the member of the bar. For example, there's an office of investigators in 5 districts across the state of Florida. One is in Central Florida, one is in Orlando. The letter that you receive will tell you what you need to do. The first thing that you should do is, if you are in a partnership, go talk to your partners. Hey, I got this horrifying, horrible letter. Get help, get immediate help, get immediately help from a colleague, unless you as a lawyer specialize in representing attorneys who are sued for malpractice. Get help. The first person that you should go to is your partner. The next thing that you do is you contact your professional liability insurer. They are a resource. If you have you should have professional liability insurance coverage. Contact them immediately, because they are your best and first resource after your partner. There are a lot of solo practitioners out there. If you don't have a partner, contact your liability provider. They have a claims department that will guide you. Florida Lawyers Mutual has in-house counsel to help guide you. You're required to notify them immediately anyway, so your coverage continues. So use them. You're paying the premiums. Take advantage of their experience, their expertise, their knowledge. This is what they do for a living. They will help you. Call your insurer.
Thank you for that. And for everybody who participated today, what we'll do is get the list of participants off of Zoom, your email addresses, and just automatically send a copy of the PowerPoint presentation, because there was a lot of good information in there. And thank you for that, Peggy. One more question. Let me see. Oh, I'm about to announce it. As far as the CLE number, it is there, 9598. It's showing in green, maybe colorblind. I would, if you would email me, I'll give you whatever the January 28th one was. I can go back and figure out what that CLE number was. So that's a specific question for me. So, back to everybody else. Thank you, Peggy, for presenting here today, sharing your knowledge to provide this important program, and to all of you for participating in this Wednesday Wisdom webinar provided at no cost to you by the Florida Bar Solo and Small Firms section. We hope that you found this program helpful and welcome any suggestions for future programming. You will need to log into the Florida Bar Members Portal to enter your own CLE course number. The course number is 9598. Again, it's 9598 for today, and it's approved for one CLE credit, one ethics, one technology. And just more comments popping up in the Q&A. Thank you for a wonderful presentation, Peggy. So thank you, everybody. And Mr. O'Brien, I will get your name down and I'll look you up on the bar website too, see if I can find you. All right. Thank you, everybody. Have a great day. Thank you,
Thank you.
Peggy.
My pleasure.